Hi, I think we're going to get started. Welcome to today's webinar, E-Signatures, Pitfalls of Using Emails and Text Messages in Contract Negotiations. This webinar is hosted by the law firm of Krokidas and Bluestein. I'm Cheryl Howard. I'm joined by my colleague, Jason Curtin. We're both practicing attorneys here at Krokidas and Bluestein. For those of you who aren't familiar with our firm, Krokidas and Bluestein is a small firm of 19 attorneys, and we provide legal services in the areas of public, nonprofit, for-profit, general corporate law, health and social services law, education, real estate development, finance, property management, public and private civil litigation, labor, and employment law. I work in real estate and transactional law, and Jason is a member of our litigation department. Combined, we have many years of experience regarding the use of e-signatures in various contract negotiations. We've provided our contact information on the PowerPoint and our firm's web address, so you can learn more about our firm and our practice areas. Before we get started, the GoToWebinar program that we're using today provides you with an opportunity to submit questions at any time during the discussion. You'll find the Questions tab on the program's sidebar where you can type in your questions. Only we, the presenters, see the questions, so you can remain anonymous. And at the end of the presentation, we'll address questions that have been submitted during our Q&A session to the extent that time allows. Now, let's get started.
We're first going to review what an e-signature is. Then Cheryl will review the Massachusetts law, and I will provide you with some of the key differences between federal and Massachusetts law. Last, we'll give you some practical advice.
All right. So we wanted to start by giving you a good working definition of what an e-signature is for statutory purposes. So as you see on the slide, an e-signature is an electronic sound, symbol, or process attached to or logically associated with a record and executed or adopted by a person with the intent to sign. And as you'll see, that intent piece becomes very critical. I was going to talk about the first bullet. So an e-signature is a unique stamp that a signer places on a document. As you can see, it doesn't need to be a person's name. To give you some examples, it could be a manually signed signature that's then PDF'd or faxed to others, a voice message, a typed name, biometric identifiers such as fingerprints, retina scans, clicking I agree, a click wrap agreement, pressing 9 to indicate acceptance. The definition is designed to be flexible and to allow for different technologies.
Now, with regard to the second element, attached to or logically associated with a record, it's a less looked at element in the 3-element test. I think a key way to think about this element is to distinguish a voice message from a phone call. So if you're speaking with the other side in a transaction by phone and you tell them, I agree to the sale of this piece of real estate, that conversation isn't recorded. It's just a phone call. But if you left a voice message and you said in your voice message, I agree to the terms that you proposed yesterday, let's close tomorrow, that then is a recorded that's a recorded record that is able to satisfy the second element. With regard to the third element, it's much more interesting. Executed or adopted by a person with the intent to sign. Now, the key aspect of that is intent to sign. Now, when you're thinking about intent, the principal inquiry is determining whether that party did indeed intend to be bound by the terms of the contract. And you're going to have the party's own testimony that, oh, I intended to sign when I sent that email. But you're also going to have the facts and circumstances that surround that signing. So the very form of how a party has electronically signed is often very suggestive of that party's intent to sign. So let's say we have Cheryl Howard speaking to a vendor of Krokidas and Bluestein, and she receives a contract from the vendor, and on that last page of the contract is a signature page. And Cheryl prints out that signature page, she takes her pen and she signs her name to that signature page, then scans it into the copier, attaches it to an email of hers, and then sends it to counsel for the vendor. There's a lot of deliberateness in that act, and that deliberateness shows intent. She went through all those steps to convey her signature to the other side. Now let's contrast that to Cheryl replying to an email in which the other side has sent her a proposed contract. And she responds, I know Cheryl wouldn't do this, but she responds and she says by way of a response email, I agree, period. And in sending that email to the other side, her signature block automatically generates on the bottom of her email. So the other side sees, I agree, and then sees the signature block of Cheryl Howard. Now that signature block very much can constitute an electronic signature. But to what extent did she show her intent to be bound by that proposed contract that she received? Well, she didn't show that much deliberateness, did she? She just wrote a message with 2 words, I agree, period, and that signature block automatically generated. So I think it's important to think about intent along a spectrum of deliberateness. How deliberate was that signature? Was it the manual signing of a document that was then PDF'd, or is it much more like this email where a signature block was automatically generated?
So I wanted just to kind of follow up on that with an example of what we see and how these electronic signatures can play out in contract negotiations. Many businesses, including ours, conduct contract negotiations over email. As we noted, Massachusetts doesn't require an official signature in a digital sense, and as Jason just mentioned, the fact that your email automatically stamps an email that you send with your name could potentially cause a problem. Even though it might not have the requisite intent, there's still that risk. So I wanted to pass along a practice tip. To avoid that consequence, include what constitutes the agreement in the record and limit the impact in the email sending the record. So, for example, you want to put language in the actual contract that says when you intend to be bound, and you also want to make sure that you communicate that to the parties up front. I work with an attorney who, whenever we start a new negotiation, he always says, just at the beginning of this, let's confirm that we're both going to reserve our client's rights to make changes to any documents that we exchange, and that the agreement will not be considered final until we've exchanged PDF signature pages. That's a great way to handle it because it provides that clarity. The other piece is that if you're going to delegate contract negotiations to lower tier employees or to agents, such as brokers or attorneys, then be sure to disclose up front the extent of their authority, and make sure they pass that along to the other side. So, for example, if you require all leases to be signed by the president or CFO, but you have a lower tier employee negotiating the basic terms of that lease, make sure they tell the other side, listen, this contract needs to go through final approval at the CFO level. I'm going to negotiate it, but just keep in mind that once we've reached the end of our negotiations, I still need that additional approval. That's very helpful in terms of creating that record. So now I'm going to go through kind of the Massachusetts statute, and then Jason will highlight some key federal differences. There is a Uniform Electronic Signatures Act that's been adopted in various forms by many to most states, including Massachusetts. Massachusetts adopted the Uniform Act with very minor changes in 2004, so we've had the statute on the books for a while. I'm going to give you some background. First, applicability. When does the law apply? It applies only to transactions where the parties have agreed to conduct the transaction by electronic means. That sounds great, but please note that whether the parties have agreed is a factual inquiry, and it's going to be determined from the context and the surrounding circumstances, including the parties' conduct. So that's very critical. It doesn't require necessarily a written agreement that you've agreed. It can be inferred from what you do. So the practice tip here is that silence can be problematic. The parties can agree or not to conduct all or part of the transaction electronically, and that they can vary the terms of the statute by agreement. Being clear about what you intend, both in the email and in the contract or document being negotiated, is very helpful to try to demonstrate when you intend for the law to apply. And again, on course of conduct, as I mentioned, your agreement to conduct the transaction electronically can be inferred by what you do. So insist on the same level of formality for all amendments, extensions, etc. For example, if you required a manual signature that it's exchanged via PDF or fax, require that for every amendment or extension of that contract.
I have a very good example of this. It was a case I had last year where my client was fortunate enough to inherit a piece of commercial property, and he didn't want to be in the property management business, so he wanted to sell the property, and he engaged in negotiations with a commercial property manager. And they came to terms and executed a purchase and sale agreement. Now, the purchase and sale agreement was signed by both parties. The purchase and sale had a signature page. Each party manually signed the signature pages and then actually sent them by mail to one another. The term with regard to modification in that PDF, that if the terms of the P&S were to be changed, they had to be changed by way of a signed writing. And that became very important because during the due diligence period, the buyer alleged to have found many deficiencies in the property that merited, in his opinion, a 40% reduction in the purchase price that was on the P&S. My client was pretty upset, but brokers for both parties decided to try to come to an agreement on what would be a fair renegotiated price. And during that renegotiation, my client's broker sent a text message to the other side's broker saying, okay, we agree to that price that you proposed, and the new closing date will be July 2nd. And that broker sent that text message after speaking with my client, who at that time agreed to the price, but had thought in his mind that he was going to get a written modification agreement, and he would have the opportunity to review it and sign it. Well, what do you know? The other side drafts that proposed modification. My client reviews it and decides that he does not want to sign it. But the buyer insisted on closing at that renegotiated price that my client's broker had agreed to. And so the issue became, did the broker's text message to the buyer's broker constitute execution of that modification agreement? Was it a signed writing? Because the underlying P&S required that any modification, including of the purchase price, had to be done by way of a signed writing. Well, we know that in the case law, courts are beginning to accept more and more text messages as constituting signed writings. 2016, we had two cases, St. John's Holdings and Donius, who the courts in both cases held that text messages constituted an effective writing for purposes of executing a purchase and sale agreement or a modification of a purchase and sale agreement. But when you look at the course of conduct of the parties through the P&S, it was to execute a contract by manual signatures that were then actually exchanged, not by way of an electronic signature. So the idea that a text message from my client's broker constituted writing sufficient for modification of the P&S was arguably not sound when you looked at the course of conduct between the parties. So that was a key fact in thinking about whether that text message constituted a signed writing. Now, another big issue that we're going to be talking about is to what extent did the buyer's broker, the seller's broker, have authority to bind my client to this revised purchase price by way of a text message. If you look back at the P&S, it was my client who signed the P&S, not his broker. So the issue of agency and apparent authority becomes very important when looking at execution of electronic signatures.
So just to kind of highlight a few more key points from the statute. The statute really clarifies that an e-signature that meets the legal requirements will be enforceable. The legal requirements are going to sound very familiar from that definition of e-signatures that we gave you. The signature has to be attached or logically associated with the e-record, made with the intent to sign the record, and the signature has to be attributable to the signer. It has to be the act of a person. But the statute makes it clear that an electronic record or a signature cannot be denied legal effect or enforceability because it's in electronic form. Of course, fraud and forgery can still be an issue, but keep in mind that can even be an issue for manually signed hard copy documents. If there's a law, in general, with a few exceptions, that requires a signature or a writing, electronic records or signatures satisfy that requirement. And you cannot exclude evidence of record solely because the record is in electronic form. So that gives you kind of a good basis for relying upon electronic documents and electronic signatures. The result is that the electronic signature will satisfy the statute of frauds That's a term that comes from the English common law, which requires certain types of contracts to be signed in writing. For example, from the English common law, an agreement made upon consideration of marriage had to be in writing to satisfy the statute of frauds. Again, the Electronic Signature Act in Massachusetts is not intended to supplant other applicable law, including statute of frauds, but it does allow an electronic signature to satisfy that requirement. I wanted to give you a little more detail on the third bullet, which is when a signature is attributable to the signer. This is where you must show that the e-signature was the act of the person. It doesn't override existing law on attribution. Again, fraud, forgery, still issues. The act of the person can be shown by demonstrating the efficacy of security procedures. So to the extent that you're using a third-party vendor that has some mechanism for requiring the person demonstrate their identity, that can be helpful. Again, it can be determined by the context and surrounding circumstances at the time of creation, execution, or adoption, including the parties' agreement. So having good language in the document is helpful. And the statute doesn't go into detail regarding whether the signature of one person can be attributed to another. Those usual considerations regarding authority apply. So again, depending on those security procedures applicable, the context and circumstances, the parties' agreement, and otherwise it's provided by law. Just a few final take-homes from the statute. Again, it's designed to accommodate different technologies. A signature, a physical signature, or a typed name is not required in the non-digital sense. And I wanted to go into whether security procedures are required. The answer is no. The statute doesn't mandate any particular security procedures. A number of providers, brokers are deploying this technology to get offers and purchase and sale agreements signed. I would say that if you're going to look into using a third-party provider, that the two key pieces would be ease of use and that they do include some level of security so that you can demonstrate the person signing has authority. But the statute doesn't provide any particular presumptions and doesn't mandate any particular use of security procedures. And last, while the focus of this presentation is on e-signatures, I wanted to mention some of the provisions in the statute regarding electronic records because some of you may be starting to store records electronically. So in general, for notices, if the parties have agreed to electronic transactions, any notices required by law can be sent electronically, provided the record is capable of retention by the other party. They have to be able to print and store the record. So if you've ever clicked on kind of an I agree button, often there's an option to print the language, and this part of the statute is where that requirement comes from. Again, it doesn't override existing law regarding how notices are posted, displayed, or sent. On the issue of record retention, this theme of establishing electronic records as the functional equivalent of paper, it continues. You can rely upon an electronic record to the same extent that you could rely upon a paper record. It allows you to convert your hard copy originals to electronic format. Information that's stored electronically is effective for audit, evidentiary, and archival purposes. And the focus then becomes the integrity of the record rather than on holding the original. For legal effect, the record needs to be accurate and you need to have the ability to access it at a later time. This can be a particular issue considering how quickly technology becomes obsolete. So for instance, if you had saved all of your records on floppy disk, you'd have to find a way of converting those files to a method of storage that you could now access. And then last, on delivery of records, the recipient must generally be able to print and store the e-record for legal effect, so no Snapchat. I was going to touch very briefly on when an electronic record is sent or received. There's general default rules. It's sent when the record leaves the control of the sender. It has to be properly addressed to the recipient, not to a system. And if the sender has done something to preclude retrieval, that would impact whether the message is considered sent. So the statute, there are some areas of law where you cannot use e-signatures. The UCC, except for sales and leases, in connection with wills, codicils, and testamentary trusts. This is a relatively intuitive example. While I think it's unlikely that a hacker is going to access your email system and sign a bunch of leases on your behalf, it's probably more likely that a relative would be able to access the computer or an email account of someone and sign a will on their behalf. And at the time you contest the will, the signatory is likely to be deceased. So authentication becomes particularly problematic in that context. And then transactions governed by certain other bodies of law. Court orders, notices, or other official court documents, notices of default, acceleration, repossession, foreclosure, or eviction, or the right to cure in the leasing context, and then insurance, product recalls, and hazardous materials. Now Jason's going to highlight some of the key differences between Massachusetts law and federal law.
The federal law is known as eSign. It was enacted in 2000. Now, the elements that we've already gone over with regard to electronic signatures apply as well to eSign. There are some differences, however. When it comes to, and I'll go over those differences, but when you're thinking about whether it's eSign or Muetta that applies, if you're working in Massachusetts, it's very likely Muetta, but you are going to be in the federal context, and eSign will apply when it comes to federal documents that you might be signing, or with regard to documents that relate to interstate or foreign transactions. Now, a key difference between eSign and Muetta deals with consumer consent. For Muetta, our state law, the standard is very permissive. Consent is determined from the context and surrounding circumstances, so very broad and vague. But when it comes to under eSign, consumer consent is very rigid. If a writing is required, that writing needs to be clear. It needs to be a clear and conspicuous statement informing the consumer of their right to a paper record, their right to withdraw consent and how to do so, the scope of consent, and requirements to access and record retention. Now, you're probably very familiar with these documents because it's all the fine print that you receive in all those bank advertisements or statements you get from a financial advisor. So that is a key difference. Now, to address some particular issues, when it comes to academic records, let's discuss parental consents. I know that's important to a lot of our education clients. Now, there's an interplay between federal and state law that's interesting when it comes to academic records. So first off, electronic signatures for parental consent are enforceable under Muetta, under the state law, except what is being consented to. If there's a federal law that applies to what's being consented to, then you need to look to that underlying federal law when it comes to the enforceability of e-signatures. So that comes into play when you're discussing academic records to third parties. So when it comes to academic records to third parties, there's a federal law that controls. That's known as the Family Education Rights and Privacy Act. Fortunately, that act specifies acceptable forms of consent that includes electronic signatures. So schools can rely on parental consent for the release of academic records that are signed electronically. Now, for healthcare entities, I know HIPAA is very important, and in the HIPAA context, healthcare providers need a patient's signature for transmission of health records to third parties. Are electronic patient signatures acceptable? Yes. The U.S. Department of Health and Human Services has stated that an electronic signature is a sufficient signature for an authorization form. Also, a HIPAA-covered entity, such as a doctor or hospital, does not need to verify the identity of the purported signer of an electronically signed document. I have not found an instance in which HHS has questioned the legal effect of an electronic signature that otherwise complied with non-HIPAA related state and federal laws. So if you were to meet the eSign standard or the Muetta standard, depending on which law controls, then for HIPAA purposes, the electronic signature is enforceable.
So what's in it for us? First, there are real efficiencies that come with new technologies. We all use email to quickly exchange comments and documents and to negotiate terms. The ability to exchange signature pages via email or via electronic signature means that parties can have a fully executed contract in hand without the need to deploy couriers and overnight mail to get signature pages exchanged. And secondly, it's probably consistent with your current practice. You're likely already using electronic signatures, so this is a case where the statute is really catching up to the practice. However, I did want to recommend that you adhere to some general standards. First, be clear about intent, both in communications with the other side and in the documents themselves. Spell out when you intend to be bound. And remember, highlighting Jason's example, saying will be bound by a signed writing is not good enough, that you need to be very specific about what technology you're going to be using. Make sure that agents or employees understand their scope of authority and that they communicate that to the other side. If someone is only allowed to sign contracts under $5,000 and they're negotiating a much bigger contract, make it clear what additional approvals are required and make sure they communicate that to the other parties. Take a look at your company's policies. Do you have a policy regarding the use of technology? Do you allow employees to use text messages or cell phones? Take a look at that policy and think about the ramifications for electronic documents and electronic signatures. Do you have a policy regarding signing authority for the company? This can be very helpful because often employees don't have a clear understanding of when they can sign something for the company. Putting that in writing, saying the CFO and the president needs to sign all leases or something along those lines, or setting out specific dollar thresholds in that policy can be really helpful. And last, employee training. If you have employees negotiating contracts, it's important to do some training. I wouldn't just stick those policies in the handbook. That they need to communicate that and make sure they understand the ramifications of that training when they're entering into negotiations with third parties.
And on that point, training of employees with regard to more informal means of communication, I think is important. Employees need to know that if they are engaging in business by way of text message or LinkedIn or other more informal forms of communication, that there is a chance that they could be binding their company to the terms of an agreement that they don't intend to. And you don't want to get into these wrangles over whether a signature is in fact enforceable. When it comes to the issues of intent and authenticity, and what I mean by authenticity is whether the person that signed is in fact the person that the signature appears to be of. You don't want to get in litigation over those two issues because they oftentimes require a fact finder. And if you need a fact finder in litigation, that often means that you need to litigate a lot to get to a judge or a jury at trial to determine those factual issues. So it's best to avoid getting into issues of intent and authenticity by having a very clear policy that your employees follow.
We wanted to highlight some concerns about the use of e-signatures. First, fraud or forgery. I think there's a sense that electronic records may be more susceptible to fraud or forgery, although I don't know that that's necessarily borne out in practice. Again, using a third-party vendor or requiring a manually signed document that's exchanged by PDF or fax can help undercut that concern. Authority. Again, confirming that the person signing the document is authorized for the company, to act for the company is very critical. On your end, making sure your employees and agents understand their scope of authority and express that in writing to the other side. Similarly, you can always ask the parties negotiating the documents for similar information. You get an understanding of what types of approvals are required up front. And then pattern of practice. Again, even if you've been very careful and you've followed our recommendations at the outset of the contract, be consistent about what you require. For amendments, extensions, modifications, it's important to require that same level of formality. Otherwise, you can inadvertently undercut all the good language that you put in your original contract. Other concerns. While access to computers is generally not an issue for most businesses, for those of you who deal with low-income populations or populations with special needs or disabilities, this may be an issue. It may limit your ability to roll out all of your forms on electronic, to have all of your forms signed electronically. You may need to make allowance for the fact that some of your clientele may not have access to computers.
And on a related point, when it comes to the third-party vendors that provide verification services for electronic signatures, they oftentimes require a logging in procedure with PINs and passwords that can be somewhat cumbersome. And I know with some of my older colleagues, they're intimidated by that process. So there may be a chilling effect when it comes to enlisting third-party vendors by requiring the other side to follow those security procedures that are required by those vendors. Another issue is public perception. I think we're, as a society, becoming more comfortable with the idea of electronic signatures. I know that manually signed documents that are then scanned and sent to the other side are routinely relied on. And courts are becoming more accepting of even text messages as acceptable forms of execution on contracts. But I think that there still is an underlying fear or suspicion that electronic signatures don't have that same import as a manually signed writing. And if you did have to get involved in litigation over, say, the enforceability of a text message, how is a jury going to perceive a text message versus a manually signed signature? So to be on the safe side, I think the standard that we've advised, hewing away from the more informal means of signature and sticking more toward the deliberate forms of signature, like the manually signed signature block that's then PDF, is a much safer course.
And last, for notarized or witnessed documents or acknowledged documents, the Massachusetts statute actually allows for electronic notarization or acknowledgement, but our experience is that the technology hasn't really caught up to the statute in this particular area. So again, you still have to maintain, to the extent the document needs to be notarized, we still generally recommend that you have that you sign that document in hard copy and have a notary notarize it. So I think that concludes the main part of the presentation, and we're going to open open up to questions. Let's take a look. So Jason, I have a question here that I think is in your area. Can an HR department rely upon e-signatures?
So when it comes to working with employees and bringing them on board a company or termination of employment, there are no specific areas when it comes to HR that are excluded from that exclude e-signatures, except when I am familiar though with termination of health insurance and also life insurance benefits. In those contexts, you need a manually signed original. That electronic signatures are not accepted in those contexts. I believe those are the only contexts that I'm aware of in which e-signatures aren't acceptable.
So I think I'll tackle this next question. What types of e-signatures would you recommend we accept? So in this area for major contracts, I would recommend requiring a manual signature exchanged by PDF or fax, or that you use a third-party vendor to electronically sign documents. Both of those require signing or typing on the dotted line. I think that's good evidence of intent to be bound. Again, helps kind of check off the boxes for the signature to be enforceable. For lower level contracts, such as purchase orders, I know those are often routinely emailed back and forth rather than formally signed. That may be fine, but again, I would be very clear with your employees regarding what constitutes a lower level contract. The dollar figure or the authority is established so that you're not inadvertently using a kind of a lower level of signature for a contract that you would rather have be a little more formal. And then, are there other areas where we should not allow e-signatures? So, I mean, keep in mind the areas where the e-signatures aren't permitted, such as wills, or not yet recommended. I just mentioned notarized documents. I didn't go into detail on this, but certain negotiable instruments, such as promissory notes or checks, are not yet recommended, even though the statute tries to anticipate a time when you could create an electronic original. For most of those, I would generally recommend that you stick to hard copy originals right now, but that may change as the technology develops.
Looks like we have another question. What about check boxes? Can check boxes constitute a signature? Well, looking back at the statute, we know that a process or symbol can constitute a signature. You don't need someone's typed name or a cursive image of a signature to constitute an electronic signature. So a check box could constitute a signature, but in thinking about it, it's not a very deliberate act. You're just checking a box. So on that spectrum of deliberateness, it's a weaker form of e-signature that expresses intent. So it wouldn't be a recommended form of signing electronically.
All right. Well, I think that's all the questions, so I think we'll wrap up the presentation.
Now, we'll forward a link to today's presentation and a PDF version of our PowerPoint to you in the next few days. Any unanswered questions or those that come in later, we'll send you a detailed reply as soon as possible. And we want to thank you for joining us today, and we hope that you found this information helpful to you and your future business transactions. Thanks again.